There we go. You guys could just give us a minute or two. We'll get started here. I know Miss Chick's on her way, so.
No, that's that one. Front and center.
Good evening, and thank you for joining us for the March 2nd, 2016 Northfield Township Planning Commission. I'd like to call the meeting to order at 7:04. If you could please join us in the Pledge of Allegiance. Mr. Stanalicho for the roll.
Mr. Iaquinto. Here. Ms. Chick.
Here.
Mr. Dignan.
Present.
Stanalicho's present. Ms. Chockley.
Here.
Mr. Kuzno. Here. Mr. Roman.
Here.
Next item on the agenda is approval of the agenda. Does anyone have any questions, concerns, comments, or additions?
Make a motion to approve the agenda as presented.
Second.
Okay, there's a motion by Iaquinto, supported by Chockley. All those in favor?
Aye.
Opposed? Motion carries. Next is correspondence. You will find, I passed out to you a letter from Ms. Robinson and a
Sir,
letter
you
from Ms.
skipped item number 5.
Oh, I'm sorry. I did. Number 5, call to the public. If there's anyone in the public that would like to address the board, you may do that at this time. You'll need to step up to the microphone and state your name and address for the record. You do have 3 minutes.
Good evening. My name is Laura Voitis. I'm at 6235 Hellner Road. I just want to come up and encourage the Planning Commission tonight to abide by their October 22nd, my apologies, ruling that informed Biltmore to abide by our master plan. Now, as I understand it, on that night, it was decided that a letter was to be sent to them, which I have here with me tonight. And I just want to read a few portions that say that they must abide within our zoning ordinances available for agricultural zone property previously identified, and that the proposal shall recognize the desire for growth that is envisioned within the Northfield Township Master Plan and must comply with current zoning. As I understand it, this puts it in their court. We should not be doing more to really put it in their best interest to come zone here. We've tried to work with them in the past. We've said that we're more than happy to have development in the appropriate way in this township. So at this point, I don't understand that if there were no objections and no other discussion of a formal process that wasn't followed at that point, I see this measure as closed out. And I think that if we are to move forward in any appropriate way, that that's something that should be thoroughly communicated with the public. And I just want to thank you for your service, and remember that we're all here to serve the community together, and this is not a unilateral action. Thank you.
Thank you, Ms. Voitis. Anyone else like to address the board? Mr. Warburton, welcome.
I just had a good trip. Craig Warburton, 450 West Joy Road. I was at the last Planning Commission meeting, and I left after the second call to the public as the comments from the commissioners were taking place. thinking surely I had walked out on 3 or 4 or 5 minutes of whatever. And I got home to find, when I looked at the replay and got some emails, that 20 minutes more business took place. That the chair took his comment from the commissioner and extended it to a huge amount of business. Discussion that involved no less than 5 commissioners, the township manager, the township planner, until finally someone of a level head spoke up and said, this doesn't belong in this part of the agenda. I watched what played out with, maybe I swallowed both the hook and the worm. I listened to Mr. Iaquinto say he thought that issue with Biltmore was closed, and I heard you, Mr. Chair, say you had that understanding too, but it had been clarified to you that that perhaps was not the case.
Correct.
And I took that to mean that letter had never been sent. So I ripped off a FOIA request, and I have a copy of the letter, and I have to say I'm very impressed with Ms. Bird's cover letter. I think it's more comprehensive actually than the memo, but notwithstanding another lecture from Mr. Fink tonight about my opinions and anything I might have to say, or comments from anyone else who cares to throw a stone or two, you voted 7-0 to send a letter with an answer to Biltmore Properties. It's on a parliamentary level, that's a closed issue. You can't just decide, I'm going to put it back on the agenda and reconsider it. That has to be put back on the agenda as the result of a motion of support and a majority approval by the members of the commission. You can't just pull them out of thin air and say, maybe we're not going to be done with this after all. Maybe we need to go at it some more. I looked at the 69 hours we paid for with Carlisle Wortman, the $6,000 plus that we paid them, the countless pages that they developed working on this project with nothing from Biltmore. And I'm absolutely aghast to see you just approve the agenda with that as old business, and it's done. Under Robert's Rules of Order, you can't readdress it without some action from the board. Maybe I'm wrong. Maybe my high school debate classes are failing me, but this surely looks like an agenda being played out. I read with great interest, just as I listened to the tirade at the trustees meeting about
Mr. Warburton, your
my
time is up.
misconceptions. Pardon me?
Your time is up, sir.
Oh, I'm sorry. I listened at great with, I'm not done.
No, wrap up, please.
All right, thank you. There's darn little way what's taking place with living water is not a conflict of interest on some level. If you guys discuss this and come to the conclusion to change the zoning, you will have bypassed the step. You're going to consider how things get to the planning commission. I was coming here when you guys were in high school, and it used to function with lightning crack order on Robert's Rules of Order.
Thank you, Mr. Warburton.
I'm not done.
You are done, Mr.
Get a
Warburton.
cop. The ordinance.
Please have a seat, Mr. Warburton. Thank you. Would anyone else from the public like to address the board? Please state your name and address for the record.
Sorry, Jennifer Delisle, 7441 Spencer Road. I'm sorry, I have a cough drop, so I will try not to cough into the microphone too much. Thank you, Mr. Roman, for at least reminding people that they were talking about serious issues that should be addressed properly. I generally discount conspiracy theories, but you guys are making it harder to believe that there isn't something going on with Biltmore. So, to say that you were surprised that the letter wasn't enough seems disingenuous when Mr. Fink told me that right after it was signed. So I don't know why he would be telling me things that you guys didn't know. So here are my immediate questions that I really hope that you will address this evening. Have any of the members of the Planning Commission, Board of Trustees, or employees or agents of the township had any contact with Biltmore or their agents in the last year? 2, what are our legal obligations, if any, with respect to the Biltmore request to amend our master plan? 3, what are our legal obligations, if any, with respect to the intent to plan sent out in 2014? So I really hope that you will address those. They're serious issues. Maybe you don't actually have to do anything. And finally, I know one of the... What are our legal obligations, if any, with respect to the intent to plan sent out in 2014? And finally, in another issue, if any discussion is going to be had, probably not tonight, but in the future, about reducing AR zoning to 2.5 acres, I really hope you won't do that. And even if you want to allow more density, cutting it down to 2.5 acres generally would create a huge patchwork. Already the 5 acres creates a bizarre patchwork of people trying to fit in the lots. If you want to allow more density, I really hope you would use the clustering and open space ordinances to give that as a bonus so that you have it really well more integrated into the community instead of having a clump of houses too close together. Thanks very much.
Thank you, Ms. Delisle. Is there anyone else in the public that would like to come up now and speak? Please state your name and address for the record, sir.
Good evening, David Perry, 9411 Earhart Road. Deja vu over again. I'm going to say the same things I've been saying all along because we really have the same issues still recurring. And that is that we have a master plan. It's been carefully crafted by many people in the community. It's a compromise document. People worked long and hard on this. And the appearance here, I don't know the facts. We can't, apparently. The appearance here is that there is a very, very small minority of people in our community who think they know how to take the direction of this community and they want to do so unilaterally. I object to that, and I feel that the community at large will eventually be served. I resent the fact that a few people in the community who have been elected or appointed to represent the community are in fact going off in a direction that is quite different than what the community wants. And if you truly believe that the community does want this, please bring your supporters to these meetings. I'd like to hear them stand at this microphone and say things in support of what you want. I'd be interested in hearing their views. I would be very interested in sharing my views with them. But when I come to these meetings, what I see here is I see 90% of the people standing at this microphone questioning and opposing the actions that this group has taken with Biltmore. And I'm asking you, are you really representing this community? And if you're not, what are you doing? Thank you.
Thank you, Mr. Perry. Ms. Burkhardt.
Kitty Burkhardt, 6187 Noller Road. I just can't believe we're back here again. Ken, you know we have to follow the rules. I worked with you on the ZBA for years. You just don't do what you individually want to do. You follow the rules. We have a master plan. We have a good master plan. The people in this township have consistently, for the last 40 years, said they want to keep the rural nature of Northfield Township. They have said we want smart growth. We want businesses that work 9 to 5. We don't want subdivisions. We don't want to be a Southfield. We don't want to be a Lyon Township. Have you tried to get through South Lyon from 7 to 9 in the morning or from 3 to 6 in the evening? We don't want that in Northfield Township. That has consistently been said by the residents of this township for over 40 years that I've been here. We need to do things open, above board, public meetings, letting people know what's going on. following the master plan that we worked very hard to get. We have improved our ordinances tremendously from when I first was here, when I was first doing ZBA. We used to have 3 ZBA meetings every month. We don't have that now because we have done a much better job with our ordinance and with our enforcement. We want to continue in the right way, smart growth, growth that the majority of the people of the township want, not what a subset of somebody who thinks they know wants. We need to follow the rules. Public represent the majority of the people of this township, not the few that seem to think they know everything. Thank you.
Thank you, Ms. Burkhart. Would anyone else like to address the board at this time? Seeing none others, we'll go on to correspondence. There were 2 letters that I handed out to you. One was from Ms. Burkhart, who recently spoke, and the other one from Ms. Robinson. Did anyone else receive any correspondence?
Yeah, I think that's from my daughter, not me.
Oh, I apologize. You're right, Kitty. It was from Katie. Thank you for the clarification. Next item on the agenda is reports. Board of Trustees report. Ms. Chick.
The board met February 23rd. The board approved an annual lighting and maintenance fee for the proposed Gateway Bridge over US 23 at 8 Mile. When construction is complete, Manager Fink is looking into contacting Green Oak to see if they will split the fee as it is a shared border. Amy Steffens was reappointed to the ZBA. Parks and Rec submitted a proposal to formalize their organizational structure. They would become a board as opposed to a commission. There will be no compensation for the board. They are requesting an annual budget allocation of $10,000 to implement some of the projects brought forward in their master plan, and the Board of Trustees will vote on their proposal at the next meeting. Discussion continues for the sewer ordinances for the Whitmore Lake Road SAD. That's all.
Okay, does anyone have any questions for Ms. Chick? Hearing none. ZBA report. Ms. Chalkley.
We have not met since the last meeting.
Okay. Staff report. Mr. Fink, anything?
No, sir.
No? Planning consultant report. Anything? Nothing at this time? Okay. We do not have any public hearings this evening. Number 9 on the agenda, old business. The first item on the agenda is a Biltmore request to amend the master plan, attachment 1. Before we get into this, what I'd like to do is ask Mr. Fink to discuss how this item happened to make it back to the agenda through his, I had a discussion with him, and Mr. Fink, could you please elaborate on that?
Sure. Previously, I don't know, probably 4 months ago, 5 months ago, the Planning Commission voted to send a letter to Biltmore Development Company, LLC, or whatever their name of their company is. Well, it's Biltmore, but whatever the rest of it is, to indicate that they would welcome, and I'm not quoting, I'm trying to remember the letter, don't quote me on it, but they'd welcome a proposal in conformance with the master plan. And that was passed by the Planning Commission 5-2. I have had conversations with legal counsel, and legal counsel has previously and currently is indicating and communicating that the master plan request, the formal master plan request from Biltmore, which was requested roughly 2 years ago, needs to be acted upon. That letter does not respond to that master plan request, and the action has to be taken by this Planning Commission. And that action has to be taken after review by the township's experts in order to provide or to assist the Planning Commission in providing a factual basis for their decision. So I understand and I respect the comments that were made But the letter that was sent by the Planning Commission is not sufficient in a determination or decision of the request that is still on the table. There is a formal master plan request, and as such, there has to be a formal decision made by the Planning Commission on that master plan request. And council is recommending that be acted upon again after review by consultants to provide a factual basis to help the Planning Commission create a factual basis for whatever their determination is. So that's why it's on the agenda.
Thank you, Mr. Fink.
I hope that, did I answer everyone's questions?
Yes. Mr. Stanalicho?
I was not here last meeting for any of the discussions that took place, but in listening to your explanation, and I take you for your word on that, do we have a formal opinion letter from the attorney?
We do not have anything in writing. I spoke with him again today, going over exactly this issue, and that opinion does come from Mr. Burns himself.
Well, you know, we went through this for our bylaws, which actually ends up being a much simpler matter, and the majority of the people on this planning commission decided to have our bylaws sent off for a formal written opinion from our attorney, which I didn't think needed to be done, which was why I voted against it. But I believe that if we're going to act upon anything, we should have a formal written opinion from our attorney stating exactly what we need to act upon. I think that's just the basis for us before we even address this on our agenda.
Thank you,
I think that's the minimum we should have.
Thank you, Mr. Stanalicho. Mr. Iquento, did you have a question?
Mr. Stanalicho addressed it.
All right, thank you. Yes, Ms. Chalkley.
Would Ms. Hodges know how to deal with one of these? Does it really need to go before the attorney to deal with the request for the master plan amendment?
Ms. Chalkley, I'm not quite clear.
Right.
Thank you. I'll get used to it. Yeah, we went through this last time. I'm not sure I fully understand your question. Right. Yes, I know how to review a request for a master plan amendment.
Right.
And to bring you back an analysis and facts that then would be before you for making a decision. I mean, in terms of having a factual basis, it's not unlike when we have a ZBA member on the ZBA where the ZBA takes testimony and facts are compiled and you have facts as a basis, or in a rezoning where you give reasons for a basis. So I would anticipate that if requested to do so or directed to do so, we would review the implications of the request in the context of your master plan and evaluate it.
Okay. So then is that what we're going to get from the attorney, like the next steps on how to turn this down? I mean,
Well, I don't know if it would be that, because we'd be waiting for factual basis. I don't know, but it depends on if we ask the attorney for something, and if we do, what we ask him for.
right, because this body requested from Biltmore quite a few things at one point, several studies, and they've responded with nothing. And they didn't respond to the letter. It seems like they're not interested anymore, which, why should we jump through a whole bunch of hoops for a company that's not interested when we can just say no?
Right. My only question would be is, did we address the original request? Did we deny it? Did we approve it? Or did we do something in between? And I guess that was the question that, in speaking with Mr. Fink, that's the question. Yes, Ms. Chick.
I guess that's what it comes down to. I mean, yes, they were obligated to respond to our communication, but as a planning commission, we were also obligated to respond to their request, and we've had no discussion on it whatsoever. We've not had any discussion. I understand they didn't give us much, but we've not discussed it at all. And I guess asking for an opinion from the attorney on what we need to do. I mean, normally, when someone comes before the planning commission and asks for an amendment change, is that something, Sally, that normally happens, that you have to get? I guess I don't understand why we're asking for a legal opinion when it's something the planning commission should be acting on anyway.
Mr. Iaquinto?
I was going to make a motion. I move to ask our planner to review the request for amendment of master plan map dated May 29, 2014 from Biltmore Land LLC addressed to Mr. Howard Fink, Township Manager of Northfield Township.
Okay, there's a motion by Iaquinto. Is there any support?
Okay.
Is
If
there,
I may.
if there's no support,
If I may.
the motion dies, lack
Oh.
of support. Yes, Ms. Chick.
I guess I wanted to make an amendment or add to it, or do you have to have a support first?
Well, before we discuss it,
Okay.
but
All right.
would you like to offer a
I'll
motion?
support it. And then,
Okay, so there's
Okay.
a motion by Iaquinto, supported by Chick.
Okay.
Discussion on the motion. Yes, Ms. Chick.
all right, I'd like to make a friendly amendment that we also ask for an opinion from our engineer, Brian Rubel, and probably from the public safety director to see what actually, get an opinion from him on what it would be like to have a subdivision if they needed fire over there or extra police, just something that we can look at as opposed to having the planner, not as opposed to, but in addition to what the planner has to add.
Yes, very well accepted. Thank you. I forgot to add that as part of it.
Yes, Ms. Trackley.
Well, so we've gone down this road once already, and we have, like Mr. Warburton said, you know, over $6,000 worth of work done by Carlisle Wortman on this. And so I'm wondering, now we're going to go down this road again and have kind of the same outlay here for an evaluation that it wasn't completed, but there was a lot of stuff there.
Thank you, Ms. Trackley. Mr. Stenalijo.
I would think that since Mr. Fink brought up the subject that our attorney is suggesting that we take some action on it, that before anything goes off to the planner again and we start the circle of this all over again, that we actually find out from our attorney exactly what it is that they're saying that we need to act upon and why, so we have a better explanation on what we're asking for and get that information in writing so that we do have something to review and look at.
Thank you, Mr. Stenalijo. Mr. Iaquinto?
I believe I know what my motion stated, but then I also believe what the attorney is referring to is the letter that I stated from Biltmore, May 29, 2014, their request for amendment of master plan map. They detail 6 different items specifically in there. And so sending that to our planner for review per their request is what we need to act on, either to approve, deny, or table this request, this official request, because understanding the explanation from Mr. Fink, we truly have not acted on this in a proper way, and according to what I'm understanding, Mr. Fink, the letter that we did submit to Biltmore didn't adequately address their request for amendment of master plan map. Is that correct?
That is correct.
Okay.
It was not, you know, as I indicated previously, I have had multiple conversations with council, and the conversations, I'm trying to explain as plainly as I can, is the conversation is that there is an official request on the table, and that request has to be acted upon by the Planning Commission, responded to by the Planning Commission, and that has not happened. And in order to do that, the council is recommending, which is appropriate and typical, in communities that the township experts provide their analysis in order to assist the Planning Commission in creating findings of fact, creating a factual basis for their determination, which in this case would be Mrs. Sally Hodges at McKenna. Sewer would certainly be as well.
Thank you, Mr. Fink.
That was the communication from Mr. Burns directly.
Thank you, Mr. Fink.
It is not in writing, but that's what he said.
Thank you, Mr. Fink. Mr. Kuzno.
All right, so we have a letter that went out there that was inappropriately said, apparently. But has the sentiment of the Planning Commission changed from the verbiage of that letter? Have we changed our opinion? We basically stated that it was not meeting current zoning and/or future, current zoning and the master plan. Correct? We haven't, has that changed at all? Have we changed our opinion on that? I guess that's what we need to ask ourselves. We have, I don't know how many pages of documentation from Wortman here. I don't think that it necessarily requires that we go to our planning consultant to give us her opinion. If we've already gotten sufficient information from our previous consultant and our sentiment hasn't changed, we just need to state clearly, denied because it is not consistent with current master plan nor the future land use plan, or we say, okay, give us more information. We've already asked for more information. They haven't given us any more as it is.
Thank you, Mr.
I don't see the need for.
Thank you, Mr. Kuzno. Is there any other discussion on the motion that's on the table right now? Yes, Mr. Stanicho.
When this whole process started off in 2014, I was not on the Planning Commission at the time, but I did sit out in the audience. And there was a lot of discussion on both the Planning Commission and the Township Board about directions to be taken. And I know that this board this commission voted to send out a letter of intent to amend the master plan. And then subsequent to me coming on here, we spent a lot of time talking about different directions that we could end up taking on it. So I don't think that we haven't done anything. I just don't know exactly what we need to respond to. And that's the reason I was asking for the legal opinion. What do we really have to do to basically make this an official response from the Planning Commission as an official capacity? Exactly what it is that we need to do to fulfill our legal obligation. Is it a request of approval, or is it an approval? Is it a request for more information? Is it a denial? What is exactly that we're supposed to be doing?
The Planning Commission.
Mr. Fink.
Sorry.
Nope, go ahead.
I'm not an attorney, but everything I know and all the conversations I've had with counsel, the Planning Commission has to determine their decision. They got to make a decision. You have to say yes, no, yes in part, no in part. They have to decide. The Planning Commission's function, when a request is presented in front of them, at some point is to make a determination. You either approve the master plan request, you deny the master plan request, you approve in part, you deny in part. Now hold on one second. I have another set of comments. Is that correct, Sally?
You have to close the action. The packet that they submitted said we ask you to amend the master plan to a certain category, and it needs to be answered. There needs to be a thumbs up or thumbs down. There needs to be a decision for reasons.
Now, in Tippett, and please correct me if I'm wrong, when that happens, the Planning Commission looks to their consultants and their experts to provide them an analysis to help them make that determination.
Okay,
So
Mr.
that's
Fink.
what.
And I understand the discussion we're having here, but we do have a motion.
I know.
And the motion that's on the table is to send it to the planner. So
I'm just
Can we
follow-
deal with that motion and have a discussion
This
afterwards?
is part of this whole
Okay,
thing for me to
go
make a
ahead, Mr.
decision.
Senalito.
So my question comes down to this then. This is 2 years now we're going on dealing with this. Why didn't the lawyer speak up a year and a half ago or longer to give us some direction like this? What now took this long to get us in that we need to take some action on this from the attorney? And I'm just asking that just as a general question because that's going to make a determination on how I'm going to vote on this motion.
Well, I will state that I addressed to Mr. Fink, is the item of Biltmore closed? Because we had that conversation, and that's when Mr. Fink, I believe, checked in with legal counsel and reported back that there was some ambiguity in knowing was it closed or not, and brought back this the recommendation that we have to take action. Yes, Mr. Iaquinto.
So then apparently, the letter that was submitted by our board did not truly address their request properly then.
My understanding is it did not deny them, it did not approve them, and it did not give them something in between. It simply stated that if they wanted to come, if they were coming here to develop, they needed to comply with our master plan.
Okay, thank you.
So, yeah.
Can I just
Yes,
make one more
Ms. Chick.
comment? Okay. So, in order for us to make a decision one way or another, because this issue has to be closed one way or another, we have to do our due diligence. So, regardless of how anybody's feeling about it on the commission, if they want to make a decision or not, if we don't have the information, all the information that we need to make a good decision, which would require the input from our experts, then we're not doing our due diligence. And legally, where does that put us if we make a decision that they can argue with?
Thank you, Mr. Roman, and then Mr. Iaquinto.
Yeah, although I'm prepared tonight to make a decision, through the chair to Mr. Fink, did the attorney wish that the current planning consultant review this? Was it a suggestion of his that our current planning consultant look at this again?
That was his opinion, yes.
Thank you.
Is that legally required? I can't answer that.
Well,
but
yeah.
that was his opinion.
Thank
yes,
you. That's a very important point
Sure.
that I didn't get from
I didn't either.
5 minutes of prior conversation.
Thank you, Mr.
Although I'm
Roman.
ready to act on it tonight, then in that case, I agree with the motion.
Thank you, Mr. Roman.
Thank you.
Are there any other questions on the said motion? Yes, Mr. Iaquinto.
That was part of my question that I had, and thank you for asking that. The other part is, so legal counsel felt that if we didn't have due diligence followed through now by our present professionals, which again is not only the planning consultant, but the township engineers, then we would be open for ambiguity and potential lawsuit. Is that correct, Mr. Fink?
Sam, I can't say that. That's
Okay.
you're asking me to interpret the advice I was given. The advice that I was given was to was that he would like our experts, and in particular, I believe that he was thinking about the planning consultant and our engineer to provide their expertise for the planning commission prior to making that decision.
Thank you.
Yeah. So I can't say why.
Okay. Anyone else? Ms. Chockley?
I'd appreciate a letter from the attorney. I mean, you get off the phone and after a while you wonder what you talked about, especially if it's a long, long conversation. I would appreciate seeing exactly in writing what the attorney had to say about this whole thing. We've been through the sewer studies. I mean, Mr. Luan did a lot of analysis. We talked about traffic, and perhaps it needs to be laid out in a more specific ways for the understanding of all of those things. And in which case, if we have to do that, I'm okay with that. But I would really like to know step by step, if it's that much of a legal deal, step by step, what we need to do to put this to rest.
Thank you. Any other questions? No? Hearing none, we have two issues before us. The first that we're going to address is the amendment to the original motion made by Ms. Chick and that amendment was to add the engineers and the public safety director to review the original motion of the planner. So the first thing we're going to vote on is the amendment, and then we will vote on the original motion. Okay? Is there any questions on that? So the first thing we're voting on is whether to amend the original motion. Okay. All those in favor? Yeah, let's do a roll call.
Mr. Roman?
Yes.
Mr. Kuzno?
No.
Ms. Shockley?
Yes.
I vote yes. Mr. Iaquinto?
Yes.
Ms. Chick?
Yes.
Mr. Dignan?
Yes. Okay, now before us is the original motion made by Mr. Iaquinto with the amendment. Does anyone need that clarified?
Yes.
Okay.
I would ask Ms.
You
Chick
want-
to clarify it, because she made a very long statement, and I don't.
Do you want me to give it a try, Mr. Iaquinto? Or you want to do it?
I mean, I can tell you what the original motion was, but as far as the amendment, I'd have to listen to a tape or ask her to be very,
It's the original motion.
to be more concise.
Okay, can you please state the original motion?
The original motion was to ask the township's planning consultant to review the request for amendment to the master plan dated May 29th, 2014, from Biltmore Land LLC, addressed to Mr. Howard Fink, Township Manager, Northfield Township.
And that motion
It
carries
was
on.
also, I did state request, their letter of request for amendment of master plan map.
And that also carries with it the amendment of adding the engineer and the public safety director to it.
Right, so
No.
now, if you just simply want to say that it be reviewed by, to ask the township planning consultant, the township engineer, and the public safety director to review the request.
Correct.
Just those two things inserted, is that what you want?
Does everybody have an understanding of the
That's what we
motion?
just voted on, yeah.
Okay. You roll call, please.
Mr. Roman?
Yes.
Mr. Kuzno?
No.
Ms. Shockley?
Yes.
I vote yes. Mr. Iaquinto?
Yes.
Ms. Chick?
Yes.
Mr. Dignan?
Yes. Okay.
Mr. Chair,
Yes.
we're moving on to 9B then?
We will be in 1 second.
Okay.
I would disclose to the public that Mr. Stolman did call me today. I explained to Mr. Stolman that he needed to address things here at the board. He simply asked if he should be present tonight. I told him that I could not advise him as to whether he could be present, that that was a decision he'd have to make, but we notified him anytime he'd be on the agenda. So just so the public knows, that conversation did take place earlier today. Next item is 9B. Mr. Iaquinto?
I would like to recuse myself from the discussion of 9B simply because I believe that the request from Living Water, which I did recuse myself, which is 9C, is the cause of having 9B on. So I will recuse myself from the discussion, as identified before, being an officer of Living Water Church.
Thank you, Mr. Iaquinto. I too would ask the commission, I do intend to recuse myself from discussion and voting on 9B as well. I do that in light of the fact that myself and my wife were part of the motion necessary in order to pursue purchase of the property that is under consideration. And at this time, unless there's objection from the Planning Commission, I would like to ask Ms. Chick to facilitate the discussion for 9B.
Okay, thank you. Okay, we're on to old business. 9B, consider churches in all zoning districts. Review and discuss comments from planner regarding zoning for churches and related questions. Ms. Hodges would like to speak to this first, please.
Thank you. The commission has our report of February 24th, 2016. In it, we review some of the comments that we made to you previously and have elaborated a bit in response to some of the comments and questions that came up from the commission at the previous meeting. In particular, I believe the comment or question was asked about whether churches had to be permitted in every zoning district. And our research indicates that they do, in fact, do not, but the community would be on firmer ground if there were if there are districts that are considered appropriate for churches to possibly be permitted by right in some locations. You do not have to do that, but it's a balancing act. It's a determination of how concerned you are about the issue or how it relates to the other uses that are permitted in the district. On page 2 of our report, I've given you a revised table, formatted slightly differently, on a zoning district by zoning district basis. And the first 2 columns give you the district symbol, the district name. The next 2 columns address whether churches are permitted by right or as conditional uses in each district. Are there uses with similar characteristics by right or by conditions? And then we've made some preliminary recommendations for your consideration. Walking through that, the RC, AR, LR, and SR1 districts currently, the Recreation Conservation District does not permit churches currently. And there are no similar uses. AR, LR, SR1 permit churches subject to conditions, and you have uses that are similar, subject to conditions, so we're recommending no change in those districts. In SR2, churches are not currently permitted, nor are any uses with similar characteristics. You may want to discuss the rationale for that. It may be that most SR lots are rather small for a church use, but churches come in many shapes and forms, so you may wish to have some discussion about that. Moving along, in the MR, multiple family residential, and the mobile home park district, churches are permitted by conditions, and similar uses are by conditions, so we're recommending no change. In the Whitmore Lake Downtown District, you have churches subject to conditions. There are some similar uses that are permitted by right and some that are subject to conditions. So this is an example of where I suggest that you think about whether you believe it's more appropriate to the nature of the community to change the use that's permitted by right, indoor theaters in particular, to be subject to conditions, because again, like a church, like indoor recreation, they're places of assembly, they have people coming and going at similar times and causing impacts on the surroundings. So that's something you might want to consider changing. The LC, local commercial district, does not currently permit churches, but it does have some other uses that are permitted subject to conditions. This is a location where you may wish to consider permitting churches subject to conditions. In the GC district, we discussed that previously. You probably should consider amending it to permit commercial recreation facilities to conditional uses and amend to permit churches as conditional uses, because it's one of those where the assembly use is by right and then you don't permit others like churches. In the HC, we're recommending you amend it to permit churches as conditional uses, no change for residential office, LI, or GI. In enterprise service, we're suggesting you consider amending it to add churches as permitted uses or amend it to permit churches as conditional uses, and change the commercial recreation facilities, particularly indoor theaters, to conditional uses. Similarly, in planned shopping centers, you may want to change theaters to conditional uses and amend to permit churches at subject conditions as well. And in RTM, where churches are permitted subject to conditions, you may want to change theaters, auditoriums, and meeting facilities to conditional uses, because if you were to get such a use in that district, it would have impacts that'd be similar to a church. So there's a lot of districts and there's a lot of different recommendations. We also supplied you, because the question was asked about wanting to see each district in the context of the other uses that are permitted. We prepared a first draft of use charts for each of the zoning district, and that's the pages that follow. You'll see when you have a chance to go through it that there are places where uses appear to be duplicated, and that's because when you actually go through the text of the ordinance, the same use is referred to in different groupings or by slightly different terms in different zoning districts. Zoning ordinances evolve over time. They're amended at different times. You think of different things when you're going through it, or there's different considerations. So that's why there is some of that in this chart, and that could certainly be cleaned up if you want to go farther with it at some point in the future. But we felt it was important to give it to you so you'd have that of a simpler tool in the context of permitting a new use or a use subject to conditions. I'm happy to answer any questions, Mr. Chair.
Mr. Stanley H. O.
Madam Chair.
Excuse me. Obviously, we're talking about trying to make it so that we don't end up getting ourselves as a community involved in a legal issue. So my question is this, is that I know that you've made these recommendations. What is the legal definition, or what legally under our current ordinances and zoning would be an equivalent of non-religious assembly or institution that we would have to then address and change those areas into making it a similar use for a church? So in other words, broken down by each section, legally, what does the law consider to be similar types of groupings or businesses, or what they call areas where you get congregations?
First, I'm going to qualify. I'm not an attorney, and I'm not giving legal advice.
I know. Yep.
From a planning perspective and from review of documentation and summaries of court cases and analyses, they are things like, I think I listed some of them in here. We looked at indoor theater, schools, auditoriums, meeting facilities, in some cases even daycare, big child care operations were considered. There's a range of uses, and if you think through how traffic flows and where people assemble, those are the kinds of things that we've identified.
So that would probably include like our community center and the library and those things as well.
Yes.
I'm sorry, Mr. Roman.
I would like to suggest to Mark too, there's some case studies on justice.gov. There was a report on the 10th anniversary, and then it's actual cases of other places in the country. So it could give you an idea of what are similar uses that churches or places of worship had with the same thing.
Okay. I just had the question then, in looking at this, is that in a community, if you have an area in zoning or a permitted use or conditional use that has anything where people assemble, then you have to end up allowing for churches to be permitted in that area, or can you exclude them as long as they are, or not have them listed down as a specific conditional use, as long as it's allowed in other areas? Or I'm looking to see what we need to do direction-wise, if we need to address that.
You're asking how far do you need to go?
I mean, because,
It's-
I mean.
in
an-
simpler
it-
terms.
An assembly could end up being a place where it is you have a restaurant. I mean, people are going there. I mean,
Agreed.
so if you have a restaurant in there, do you have to end up having a conditional use for a church to be in that area too? Or are they considered to be two separate types of entities? And can you not have that as a conditional use as long as you have that allowed in a different area? Does that make sense?
The language that comes, the language that's in the statute is that no government shall impose or implement a land use regulation in a manner that imposes a substantial burden on the religious exercise of a person, including a religious assembly or institution, unless the government demonstrates that that burden is because it's in furtherance of a compelling governmental interest, which is stuff like public safety, and it's the least restrictive means of furthering that governmental interest. And you have to treat the institutions on equal terms with those similar things. That said, it's your community, it's your zoning ordinance, it's your land use, and these are choices and decisions that you make with knowledge of what the potential application might, the impacts on the application might have.
I think Mr. Roman had a comment first. No, are you good?
I was just gonna give my opinion on what I think, but if you wanna.
No, go ahead. I want to hear it.
Go ahead.
I was gonna go more direct to the report at this point. I'm in agreement with all the, I have to back up. I do have to apologize to Ms. Hodges from last meeting because it was laying in the woods, that there were assembly uses in there, so I apologize for that comment last time. I do agree with all of the considerations here. I have a comment on SR2. Just because there's an existing church in that area, basically it's a non-conforming use at this point. So I'm trying to make this like easy as possible because this is quite a large range of adjustments. And although, yes, there is a church in that zoning district, if we were to leave it alone, it's just a non-conforming use and structure, correct?
That's correct.
So really, it would only come up if there was to be a proposed new site where it would be looked at. Okay. But I agree with all of the adjustments, but I do have a comment on the ES. Out of the two options, I would prefer to amend the second choice, amend to permit churches as conditional, and amend to change the commercial recreation facilities to conditional uses. I would prefer that to go that way than to just throw it on as a permitted use. And it also, I think, is a little more consistent throughout because all the places of worship would be conditional uses. And I only have a comment on the RTM district. And this had come up in the past. At this time, it is permissive. It is allowed as a conditional use. Am I correct?
Yes, it is.
And but the problem is that was brought up previously at the previous discussion at the time it occurred, was that this is it's not a very large zoning district, and there are some existing structures in that zoning district, and I would like to see, and this is just my opinion, that these other assembly uses such as theaters, auditoriums, meeting facilities could possibly be looked at to just eliminate those, just like it is in general industrial and a couple of the other districts. I'm just saying that's because of the actual size of it, the location, and what you're actually trying to accomplish with the RTM. And somebody might have a different comment, but those are the two avenues that I would look at as far as the suggestions go.
Mr. Stanleyjo?
So if we act upon your recommendations for using and changing these, these two conditional uses, whether it be churches or the meeting places, and to basically make things on a level playing field. Is that an action that we actually have to take at this point in time to equal them out, since it's been brought up as a subject that we're not treating everybody on an equal basis under this law? I mean, it sort of comes down to, my question is that now that we're made aware of the fact that we aren't, we have this issue, if we don't act upon it, does that end up making it more of a possibility of having a conflict later on if somebody comes up and says you've been made aware of this and you haven't acted on it?
I guess that's a legal question, weighing of risk. I think it's, my recommendation is that you do it. I think it's the fair thing to do, and it is consistent with the federal law.
All right.
And lawsuits are not uncommon under RLUIPA.
Mm-hmm.
There's, I think Mr. Roman would agree in looking at the case studies that are out there.
So if we were going to, take any action or do anything, is this something that you'll be able to then direct us through on the amendments to our different zoning areas to make them all compatible and legal under these statutes?
If it's the commission's desire to go forward and pursue amendments, I would put together proposed zoning text for each of the districts and bring it back to you for consideration.
Is that you need that as a motion then, correct?
I would need that as a motion.
All right.
Yeah, go ahead.
Yeah, I mean, Mr. Kuzno.
Oh, sorry, Mr. Kuzno, go ahead.
I'm in agreement with most of your recommendations here. I find it odd that SR2 does not allow it by conditional use when you have SR1 directly above it and MR and mobile homes, so to speak. I mean, what's so special about SR2 that we wouldn't have it there? This is not a commentary on you, it's just a commentary on our ordinance. I would suggest that we should probably allow it similarly to the SR1 and the MR. And I think I'm in agreement with Larry's idea of the RTM. I know we discussed that specific property before, and there was an issue. Your concern is that if we allow that in there, and we've limited what else can go in there because there's such little area that's covered by that zoning right now, correct? I mean, that's your thinking?
That was my point, yes.
So, although I was in agreement at the time, I didn't want to be blocking something going in there, but at the same time, I think your point is valid that it may be limiting some real research and technology manufacturing going in there.
Mr. Stanley Jones.
Just to clarify, you want to suggest having the conditional use for churches removed from the RTM, or I'm just looking to see what your direction you're taking.
Yeah, I think so, and then that would also take away the other option too. So we'd have to take away the auditoriums and theaters out of there to go back to the level playing field, I believe. Is that how that works? If we take the churches out, we have to take the other assembly uses out as well.
Yeah.
Yeah. So.
Did you? Okay. I agree with that, Mr. Roman and Mr. Kuzno's assessment of the RTM, and I am comfortable with all the other changes that you're proposing, Ms. Hodge. So, does anybody else have anything else to do? Oh, Ms. Chalkley, sorry.
I would just like to go down. I agree with the SR2 having churches as a conditional use in SR2. I would, getting down to Whitmore Lake District, I'm just thinking everything ought to be conditional. I'm not sure what you mean by right here in that third column. Uses with similar characteristics are by right allowed. The recreational facilities, particularly indoor theaters, that's all allowed by right. So that means we need to have churches allowed by right? No.
If you make those facilities that are permitted by right subject to conditions, then you've got a level playing field with churches.
So that means moving them, all of those other things into the conditional use, and then it would allow churches as a conditional use.
Right.
Taking away the by right. I could be fine with those all being conditional uses, considering the size of that whole district down there. So removing the by right. I notice you keep bringing up particularly indoor theaters in parentheses. Is that the way it is in our ordinance, or are you pulling that out because can be an issue because there's a lot of people associated with it, theater?
Usually the language in the text said something like commercial recreation facilities, including bowling alleys, indoor theaters, and so on.
Okay.
So out of those things, it's most like an indoor theater because people come at the same time and leave at the same time.
Okay, okay. So I would be comfortable with removing the by right for all of those things in the Whitmore Lake districts. I do agree with amending the local commercial to permit churches as a conditional use. Under general commercial, it looks like a lot of these are allowed by right. I would prefer if it got moved into the conditional use category, if that makes sense to everyone. Yeah. Well, she didn't recommend that.
Yes,
Yeah,
I did.
did.
Oh, did you? Because
Yes.
there's no little, okay. Then I misunderstood that. And under enterprise service, I like the second half better, making it a conditional use and getting rid of the permitted. The planned shopping center, are you recommending changing it all to conditional use? And if you are, I agree with that.
You can bring that up.
Under which one?
The planned shopping center at the bottom,
Yes.
that's all going to conditional, okay. And then RTM, I have to agree that it'd be nice to preserve that space. The argument made at the time when we had considered the churches in there was that they operate on two different, there's weekends for the churches or in the evenings, and then there's the daytime for the businesses, and so the traffic was really complementary. And that was one of the arguments for that, and so we said, well, okay, it can't be that bad to do it. Now, I am concerned with the space allowed. However, we are seeing amending to change theaters, auditoriums, and meeting facilities to conditional uses, and those specific features were allowed in the RTM so that the businesses could actually have training and, and have the meeting, and I'd hate to take that away from them, and remove that whole thing. If we remove that whole thing, then churches aren't allowed, but then the businesses don't have what they need. So I'm weighing that back and forth.
Mr. Stanley Joe.
I'd like to make a motion that the planner is directed to facilitate the recommendations for zoning changes as presented tonight, making churches conditional use along with other similar uses that currently are permitted to conditional use. And then in the RTM district, put forward the verbiage to remove churches as a conditional use.
They already are conditional use
What?
in the RTM,
What is?
churches.
We want to
right?
remove it. That way we don't have to do this other stuff.
Well, but if theaters are in there, then we have to have them in there, right? If meeting spaces and.
Oh, yes, you do. If you've got similar uses, then you should
Excuse me.
permit the
I'm
churches.
sorry, but we have a motion on the table. Can we
Sorry.
get support, and then we can have discussion?
Okay.
I'll support.
Thank you. Okay, discussion? Anyone?
Well,
Mr. Rowan.
I think I wanted to clarify the motion with Mr. Stanalacho, I guess, however you want to do that.
Go ahead.
removing it as, removing places of worship as conditional use in RTM, but we're also removing the other assembly uses in that district.
Okay.
Just to clarify.
Gonna
And I
amend.
think that's what,
All
I
right,
think
I'll-
that's what Mr. Stanleycho had in mind.
I will, yes, I'll make sure I clarify that so that those also are going to be removed. Those permitted uses currently,
Yes.
theater, auditoriums, meeting facilities.
Mr. Kuzno.
Thank you.
And then just back to the SR2, is anybody in agreement that we could allow conditional use there as well?
Yes.
I Yes. was,
yeah.
Okay.
Okay, we have
Yes.
motion, okay. We have a motion by Mr. Stanleycho and support by Mr. Roman. You have a roll call vote?
Could I just clarify the motion
Yes,
first before we
go
do
ahead.
that? Could you read that back, please?
Glad you said that. The planner is directed to facilitate the recommendations for zoning changes as presented at this meeting, making churches conditional uses along with similar uses allowed by conditional use, and amending the RTM district to
Eliminate.
change theaters, auditoriums, and meeting facilities to conditional uses.
No, and
Eliminate.
remove churches and the other theaters, auditoriums, and meeting facilities from that district.
So to remove
Yes.
churches, theaters, auditoriums, and meeting facilities as conditional uses?
No, just remove them. They're not allowed in that district.
From, as
As
uses allowed
RTM.
in the district.
That's what we discussed, right?
Right, okay. Can we have a roll call vote, please, Mr. Stanleycho?
Ms. Chick?
Yes?
I vote yes. Ms. Chalkley?
No.
Mr. Kuzno?
Yes.
Mr. Roman?
Yes.
Motion passes. Go ahead, Mr. Dignan.
All right. Well, the next item on the agenda, I also am recusing myself from, and I guess I'm going to look for a little direction on how we're going to deal with this in light of the motion that was made and passed on 9B. I guess I'm going to look to staff, if the commission's okay, and ask Mr. Fink and maybe Mary, can you guys, how do we respond? We have a request that we have to answer, right? I mean, we talked about this earlier with the Biltmore development. We have a request from an applicant to do something. We've acted not to the applicant, but we've acted to our zoning. How can that be handled? Can that be handled with a letter from staff advising the applicant? Or, I mean, you guys tell me, I'm kind of lost here.
But before you do that, I need to recuse myself from the discussion as well.
Yeah, I'm simply talking process right now. I'm not discussing the matter itself, just process-wise, because obviously I can't I can't be part of the discussion of this item either. Anybody? Yes, Mr. Roman.
Are you recusing yourself also from the discussion?
On the item, yeah. I can't be a
then-
part of the discussion on the item, but I'm asking
Then
you-
I feel that, that
Okay.
Ms. Chick should.
I guess I'm asking a procedural question based on an applicant.
I'm with you there, but I think
Fine.
Ms. Chick
Well,
should
we can have
run.
Ms. Chick ask that question then. Go ahead, Ms. Chick.
Okay, so, Mr. Fink.
Well, I can give you my opinion,
Okay.
but I really, I would defer to Sally on this process. But here's my opinion. My opinion is that it's slightly different. You know, previously we had, I think Mr. Digdon brought up the previous request that we had. The previous request was an official request to amend the master plan, which is an official request that exists in our process and in statute. Well, I don't know if it exists in statute, but it would exist in our process. It would exist in statute, right, Sam?
Request to amend.
A request to amend the master plan? Yeah.
Yes.
Okay. So what the churches, Living Water Church has requested is a request to amend the zoning ordinance, which doesn't exist in our process. So I guess my opinion, and again, I do defer to Sally on this because Sally is the expert. My opinion would be that the Planning Commission ought to probably make a motion and, if they wish, in a second, and vote and determine whether or not you all want to review the ordinance request for Living Water Church. I don't know how else to proceed.
It's just,
I think we just did that. We just ended up directing to get the language for these different zoning districts to include the changes that's just recommended so that we can end up looking at that and then acting upon that.
Ms. Hodge.
If I can respond, I think you've got two separate matters in front of you that have been combined. They were combined in one in a letter from the church. One was asking you to consider whether you would permit churches in the general commercial district, and the other was having to do with their property and directing you to, and asking your opinion on that. I think the request, the township could improve its processes, and we'll talk about this more later on the agenda, but when something like this comes in that's speaking primarily in the interests of a single party from an individual or a single site, they're asking about their property, that it ought to be taken and direction ought to be given. I think that, in my opinion, the church ought to be completing an application at some point to request rezoning, or excuse me, to move forward on the application, or if they're asking you to consider a text amendment to permit churches, then that should be in the form of an application to the Planning Commission. A request that comes to you should be treated as an application, and I think it would behoove us to have an application form for that. It keeps it orderly, in process, and on a path so that you do follow it through and get the answer that they're asking for. The Planning Commission you can always decide in your process of review if you want to take on other matters. But this was a question for the benefit of an individual property, which they have the right to do. But.
Thank you. Mr. Stanley-Cho.
I think we as a commission here have already addressed the fact that we are, since we're asking for this verbiage to be brought back to us, I think it's a good indication that we are, in favor of having these changes take place. Just that it's the process that needs to happen. Even though we approve the verbiage, it still needs to go to the township board to have them approve the final language of this. So I would think that the church should end up seeing from the action that we took tonight that we actually are in favor of that, just it's a process that we need to go through.
And my comments are directed mostly at the future, because this will undoubtedly come up from someone, somewhere, again, if it hasn't in the past already.
Mr. Roman.
I agree with Mr. Stanley-Cho. Really, if just because of timing, had this request letter come, later in this process, although it did spur the whole consideration of what we just did in 9B on the business, but really it goes away. We're going to make the changes, but I do agree also, yes, we do need application process, and along with that, we need a fee process, I think, too, because we could be reviewing tons and tons of things through the planning consultant at our cost. So.
Ms. Hodge, would that be something that you would draft together, would be an application process, or is it something staff would put together?
I'll defer that to staff. I'm certainly available to assist.
Okay, I do agree that that's something that we need going forward. Any further discussion, Ms. Chalkley?
Yeah, and this really is two questions when I see this. Is it, our church is going to be allowed in general commercial? And, but that doesn't require us to approve their conditional use when they come to us. So it is really in two parts, like you said. And really any, like the ZBA has come to us to get changes. The Board of Trustees can come to us asking for changes. Citizens can come to us asking for changes in the zoning ordinance, and we can consider all of those things. So yes, this process would be wonderful to actually have a real process. But this particular letter is two parts, so it doesn't guarantee them anything, really, even if we do change this. And it's quite a long process. So we've got this, and in 2 weeks we might see another one, and then we're going to have to post it, and then, you know, and then it will eventually move on to the Board of Trustees. So it could take quite a while to get a final answer for the church.
Any further, Mr. Roman?
I understand what Commissioner Chalkley just said, but it's on no part of anybody. If you go ahead and do further of review of any kind based on what we just proposed on changing, you're making an exception, I think. So I feel it's unfortunate, but it will be permitted, but the steps just haven't gone through yet. Did I misunderstand?
That's what I said, yeah.
Okay, I'm sorry.
And it's going to take months.
Okay, anyone else? Any further discussion? Okay, so are we ready to, I'm sorry.
No, I think we're ready to move on.
Okay.
Thank you, guys. Number 10 is new business, which there is none. Number 11 is minutes from the February 17th regular meeting. Those were included in your packet. Does anyone have any changes to the minutes? Yes, Ms. Chalkley.
Yeah, I know I usually make minor corrections to the minutes, but I did not make any last time, and I let Ms. Lemble know, so that's on under
okay.
11.
Yes, Mr. Sanalicha.
I move to accept the minutes as presented.
Support.
No, as amended.
As amended.
Oh, as amended.
I'll second that.
I supported it
Yeah.
already.
Oh, you did, sorry.
There you go,
Sorry
beach to
about
it.
that.
Motion by Sanalicha, supported by Iaquinto. All those in favor?
Aye.
Opposed? Motion carries. Next item, policy review and discussion. The continuation of goals and objectives. It's attachment 4, but there was an updated version that was distributed because a couple commissioners got some information back. What I've done is assembled the information that you guys have given me into a list. There's 11 objectives on here, and we can do this differently if you folks choose to. What I was asking is if you wanted to go through it and number them 1 to 11, 1 being your highest priority, 11 being your I hate saying least importance, but because 11 items might be 11 high priorities, right? But and then get them back to me. I would compile that, give you a printout of everybody's at the next, possibly the next meeting, and we can then go further from that.
So complete this, take some time to think about it and not do it right now. is what I
No.
mean.
Take some time to think about
Okay,
this.
Good.
Yeah, absolutely. And get it back to me. I will compile that. It will be made available to the public. Everyone's, as it has in the past, everyone's rankings will be made available, and then we can look at where we're at and have a kind of a complete discussion about what we do to address our top, 2 or 3 priorities at that time. Is everyone in agreement with that process?
Mm-hmm.
Wonderful. All right, next item on the agenda. Review the process for an applicant petition to the Planning Commission. Hey, here we are, back at this three times tonight.
Yeah.
No, at our last meeting, we had asked Mr. Fink to provide for us kind of a rundown of the process for an individual just coming in and making a request to the Planning Commission. And
Yeah.
Mr. Fink, would you like to address your letter?
Yeah, so, well, earlier, sorry that I suggested something that you've just previously done.
Nope, you're good.
So I'm not sure what I was thinking. I was kind of, yeah, we keep kind of getting at this, but just to be quick and have some brevity, I won't go through the living water stuff. I think we do need I agree with Ms. Hodges. I think we need a formal application at this point, and I agree with Mr. Roman that I think that there needs to be a fee associated with it. I think the fee probably needs to be something similar to what we currently have for a site plan sort of process or PUD process or whatnot. And I think that the formal application needs to be specific to a property owner and property sites. And Ms. Hodges and I, we've spoken about this, so it's not just my idea, it's also Mrs. Hodges. But I think it needs to be specific to a site and an applicant. I hope I remembered that correctly. Because we can get requests for changing the ordinances from the public. We could get requests for changing the ordinances from lots of different individuals, and the Planning Commission should hear those requests from the public and from any individual and give some thought to that and determine if they want to act or not. But in terms of if somebody comes forward and indicates that they have an issue with a particular ordinance because they are trying to buy a building, do a development, create some kind of sort of official action, then I think it certainly requires a formal application and should have a fee structure associated with it.
Okay. Yeah, Mr. Iaquinto.
When you say a fee structure, you're referring to, there wouldn't be one set price, it would be depending upon what the informal request would be, correct?
You know, I would like to, I guess, to have the opportunity to kind of really give that some thought and go over it with Ms. Hodges and understand it a little bit deeper. I will tell you there's pros and cons to both, Mr. Iaquinto. Certainly, for example, in this particular case, it generated a conversation, and that conversation generated review and analysis by our consultant, and that analysis will cost us money. I mean, that's the reality of it. If we set a blanket fee, it may not cover the total amount of that analysis, and sometimes it might. So I think we really have to give some thought as to what that fee is. The other thing is you also have to give some thought as to not just what that particular fee is and what that particular issue is, but in general, what are the total revenues that are coming in and the total revenues that are being expended in the department related to fees and planning, and make sure that they're in balance. So, you know, sometimes we have a set fee, and sometimes it's on an hourly basis. So, I'd have to give some thought to that.
Did you have a follow-up, Mr. Iaquinto?
I did. I would agree on some perspective of that, but like as an example, this request that came in front of us, to me, is helping us properly address issues that are clearly present within our zoning districts that should have been brought up in the past when we even discussed this in the RTM district in the year 2014 when it was brought out by our planner. I mean, our planner at that time never identified the arugula Act to us, which apparently came out in 2000. So this instance is something that is helping us clear up and protect the township and shouldn't be to the detriment of an individual or a group that's bringing it forward either.
Okay, yes,
May
Ms.
I,
Hodges.
It may be that the fee that you set is, it might be a set amount that would cover be for a portion of the application. If it's the type of an application that generates additional review, the commission might make the choice then to go beyond the scope of the original request, and that additional work would be covered from general funds or other sources, or not. You choose not to go forward with that. But the steps of asking an applicant or an individual to file an application and pay a fee at some level makes it official and formal and gives importance to it, because you're going to spend time on it.
Correct.
And they're concerned in spending time on it.
Thank you, Ms. Hodges. Mr. Stanalicho?
I think that having a process in place just makes sense. That way it's not hodgepodge and hit and miss. In my opinion, we should end up being a similar fee as a site plan. I'm not sure what that fee exactly is at this point. If it's graduated based upon the amount of time and effort. All right. So I think that if you're going to end up setting up a fee, it should end up being a similar fee as, say, a site plan, something along the lines like that for this, rather than making it where it's an open-ended question on how much it's going to cost. I just think that's fair. Some of the costs that we end up doing just has to be eaten by the community because of what we do.
I agree with
So, I mean, that's my opinion. Now, the other question I have is that, do you need to have a direction from us, like a motion for you to start to facilitate this? And the third thing is that any fee that comes up, it has to be approved by the township board anyhow. So, this is just to get the ball rolling.
Yeah, to answer, Mr. Chair, or Mr. Chair.
Yeah, I have one more thing to add. I want to make sure, though, that we're not putting a fee in place that essentially, puts a burden on the general public that they don't have access to the commission. Because they have every right to have that access without it being an undue burden. And so I want to be real careful there as we go down that, because while I understand for certain types of requests, it makes perfect sense. On others, it very well may not. So I don't know how we deal with that. We may be something that we deal with along the way as things come up. But we also don't have the ability to waive a fee. It's only the township board that has that ability. So, yes, Mr. Fink.
Yeah, if I just may respond to Mr. Stanleychko and also you, Mr. Chair. So, yes, number one, I think we do need a motion. I would certainly request that of the Planning Commission. And with respect to the fee is the domain of the township board. We certainly can discuss it here. I don't think that's inappropriate at all, but ultimately it is the domain of the township board. And third, I do wholeheartedly agree with not making it cost prohibitive. I've actually recommended fee decreases almost across the board, both for the ZBA and for the Planning Commission, for that very reason. So I think that, yes, you have to balance. You have to balance our governmental interest and governmental responsibility in the work that we do, and regardless of whether or not there's fees associated or not, we have to do that work, and making sure that we're certainly not losing tons of money and spending taxpayer dollars inappropriately. And you also have to balance it with making sure that the fee is appropriate for folks to come in and utilize the services of the Planning Commission. So I agree 100% with all the things that have been talked about. I think what Ms. Hodges and I need to do is sort of hash this out and sit down together and kind of present something to you, but a motion tonight would be appropriate to move that forward.
Thank you, Mr. Fink. Ms. Chick?
Yeah, I think it would be prudent, because we've done this in the past when we were looking at fees, to look at other communities, what they charge or what they don't charge, to establish what our fee level should be based on our township, so.
Thank you. Yes, Ms. Chalkley.
I think it would be appropriate to have a process for just the public to make suggestions, maybe, that we put in the queue. We have not gone through our whole zoning ordinance, and I know there's a lot that can be improved. I know we've got invasive species listed as recommended landscape plants, you know, as, you know, I'm a master gardener, so I took a look at that list, and, you know, so we really do need to take a look at improving some parts of that, and suggestions, you know, from the public might just help us do a better job when we actually go through that without some fees associated with that.
Okay.
That's a good point.
Yeah, I'll come back to that. I got a comment on that note, but Mr. Roman, anything? No? Let's just, Mr. Sanalicho?
I'd like to make the motion that, to direct the township planner and the township staff to get together and make recommendations to the planning commission on a process for applications coming before the planning commission, along with any type of fees that they feel are appropriate for us to review.
Support.
Supported by Mr. Roman. Any questions on the motion? Again, motion by Stanalicho, supported by Roman. All those in favor?
Roll call.
Aye.
Aye.
I'm sorry? Roll call? Okay, roll call vote, please.
Mr. Iaquinto.
Yes.
Ms. Chick. Mr. Roman.
Yes.
Mr. Kuzno. Ms. Chalkley.
Yes.
I vote yes. Mr. Dignan.
Yes. Thank you very much. Next item is call to the public. We'd like to invite you back up to the microphone. If you could come up and speak your name and address for the record. Welcome back, Mr. Warburton.
Excuse me. My name is still Craig Warburton, and I still live at 450 West Joy Road. I am thoroughly confused by what took place here tonight. If you go to the website and you open up the Planning Commission portal, you can pop open this Northfield Township rezoning process. It's a 4-page document. The last page is graphic if you can't follow in the paragraphs. Right below that is the Northfield Township conditional use review process. And it is, again, 3 pages of text with a graphic interface, so to speak, at the back, if you can't follow the paragraphs. There's a 30-plus page process manual for site plan submittals. I requested the township fee schedule, and had Biltmore been required to file a request for rezoning, they would have been required to pay something in the realm of about $8 grand, which would have just about covered what we spent, what you all spent. And that's defined as $750 for the administration fee, $1150 in fixed fees, Carlisle Wortman, it hasn't been amended for the new planner, plus $15 an acre. And it has right in there, they pay the planner fees for analyzing it. Conditional use permits, about $21.50. There's 40-plus fees scheduled out for varying requests from this township. The Planning Commission has existed for a long time, and I can't believe we really assume that we don't have a process in place. I've said for the last 2 or 3 meetings that living water was improperly brought to this board, and it should have had an application. I was thrilled to hear the planning consultant agree with that tonight. You only considered the RLUIPA because of living water coming to the board, but it should have been a zoning request. And that zoning request does include specificity as to whether it's a map or a text amendment. And it requires things that Mr. Fink tells me don't exist. It says you take 11 copies of your document and you give it to the township clerk. And then she immediately, or he, immediately schedules a public hearing. And signs get erected on the property. And a series of events fall into place that really can't be misinterpreted very well. And it's in a 400-plus page zoning document that is, again, available for 1 click on the website. I don't understand why we don't use this stuff. I have hundreds of pages from Carlisle Wortman on the Biltmore request. You have spent thousands of dollars on that, and you're going to embark on it again. If you actually read Ms. Bird's letter, there was a paragraph beyond
30 seconds.
the memo, the motion. It said, enclosed, please find a site plan review application. Northfield Township utilizes the site plan process as a tool to ensure the highest quality of site design, engineering efficiency, building architecture, and landscape development. In implementing this process, the township endeavors to protect the interest of all parties involved. If you decide to submit a site plan, a pre-application meeting might be of value. I don't know how that's not conclusive. We're not playing in your ball game. We're not going to ride on your merry-go-round. I thought it was a wonderful addition to it. I had this.
Please wrap up, Mr. Warburton.
Oh, there you go.
Thank you, sir. Would anyone else like to address the board at this time? Seeing none others, we'll move on. Comments from the commissioner. We'll start to the left here. Mr. Roman, anything?
None tonight, thank you.
Mr. Kuzino? Ms. Chalkley?
No, thank you.
Mr. Stanalicho?
I want to have everybody remember our men and women in uniform. They are the ones allowing us to have this freedom of expression by their sacrifices. Thank you.
Ms. Chick?
I have nothing, thank you.
Thank you. Mr. Iaquinto?
Yes, this is in respect to one of the statements that came from Call the Public. As a planning commissioner that is out active in the community, as a number of us are, I do hear from a lot of people that are sharing with me what they would like and what they would like to see and what type of growth. And I do encourage them to come to the meetings and to speak up and to share that. For whatever reason, they elect not to, or I also encourage them to submit a letter. So I do hear from people, and that is some of the basis of some of my rationales for decision. I would like to thank, on another note, thank Sally for her precise evaluations that have been presented to us thus far. And again, I'm just wondering why our past planner did not, when we've discussed zoning in multiple times, why the RLUIPA Act, which came in effect in 2000, didn't come up. I'm just, as someone stated, kind of confused why that didn't come up in the past. I would also ask our planner to include with their statements or recommendations, i.e. a motion to either approve or deny, including clarity in the zoning on the basis, which would kind of give us some help so that we are being very thorough with our motions. Okay. I also feel that the RTM district, if we take a step back and remove the specific statements that we have, which is meeting facilities, auditoriums, and remove those, and I believe that's where the direction was, to remove that entirely from the RTM, we're taking tremendous steps back. And the RTM was created for very specific reasons, and having conditional uses for those areas and allowing those specific conditional uses, I think, is very important. So going forward, I would just ask the commission to think about that. Thank you. And would like to share everyone, the lake is very unsafe, as all other area lakes are, so please be very conscious on any ponds or bodies of water that you proceed on. Thank you.
Thank you, Mr. Iaquinto. Let's see. All right. I don't really have any announcements unless you all want to go to a middle school band and choir concert tomorrow evening at 7 o'clock. It is happening at the Whitmore Lake High School, and I think those young men and women, or kids, would absolutely love to have you there. I would like to thank all the members of the public for coming out tonight. I know that sometimes these meetings can be grueling and long. We appreciate you coming out, your dedication to the community. and your willingness to be here and to be heard. The next regularly scheduled meeting will be on March 16th, 2016. And that's all I have.
Motion to adjourn.
Motion and support to adjourn. All those in favor?
Aye.
Aye. Opposed? Motion carried. Thank you. 8:47.